Good morning, everybody. Good morning. At this time, I'll call to order the January 13th, 2025 Subdivision and Development Appeal Board hearing. My name is Andre Gianandrea. I will be the chair for this hearing. All questions and comments should be directed through the chair. At this time, I'll ask the board members to introduce themselves, starting from my right.
Councillor Tanya Faubert.
Bronte Valk, board member.
Sorry, we're navigating a new microphone system up here. So. To the board and administration, are there any additions, deletions, or changes to the agenda that's been presented to us today? None. I move that the board approve the agenda as presented or amended. All those in favor? Motion is carried unanimously. Today, the board will hear an appeal by the appellant of a decision by the Development Authority to approve development permit application PL 202-403-62 for accessory use and accessory buildings, accessory Nordic spa amenity. This is an appeal against an approval and conditions of approval by the Canmore Development Authority. This part of the hearing is an opportunity for the appellant and the applicant to introduce themselves and to voice any objections you may have with board members present. We are aware that this is a procedural matter in regard to board members' presence that need to discuss. So we'll address them after the introductions are finished. With that, will the appellant please approach the podium and introduce themselves?
Good morning, Mr. Chairman and members of the board. I assume, because I can hear myself, that everybody else can. Thank you very much. Good morning. Again, members of the board, town administration, representatives for the applicant team, and any other people present today for the meeting. My name is Bonnie Anderson. I'm a lawyer at Rose LLP and am joined today by co-counsel Ms. Samantha Stokes. We represent the adjacent landowner and affected party, Stone Creek Resorts. We'll refer to our client as either Stone Creek or the appellant. Just for basic housekeeping items, I guess I should ask before we go much further is, we're not going to get into the sort of the merits of a merit hearing at this point. It would be fine to introduce and go through the adjournment topic and the panel topic that we had outlined, or how would you like to see this move forward in terms of the next steps?
Well, following this, we'll give the applicant an opportunity to introduce themselves. And I understand there's a procedural matter we need to discuss before going through as well. So
sure, so I won't get into the procedural matter right now. Is that the case? So I'll let Mr. Homersham come up. Thank you.
At this time, would the applicant please approach the podium?
Thank you, Mr. Chair, members of the board. Robert Homersham. I'm a lawyer and counsel for the applicant Canmore Hotel and Spa Limited Partnership. There are two issues that I understand before you today. One is an adjournment request. The other is, I'll call it an allegation of bias with respect to panel members that sat on the prior appeal of this Nordic spa. I think that, and I'd like to introduce at the appropriate time, once the appellant has made their submissions regarding the adjournment request and their allegation of an apprehension of bias. When it's my turn to speak on those two issues, I also want to address a third issue in that it is our view that the notice of appeal does not disclose an appealable issue. And so we're going to argue that it should be struck for that reason.
Thank you.
Thank you.
Does anyone in the audience affected by this appeal object to any present board members hearing this appeal? So, as mentioned earlier, before we hear the evidence, there is the procedural matter that the board needs to address. One being the request for adjournment, and the other, the request for a new panel. If we could hear on the request for adjournment at this time, please. My apologies, I didn't introduce our legal counsel who's joining us, Janice. Sorry, Janice, if I could ask you to introduce yourself, please.
Sure. Janice Agrius. I'm the legal counsel for the SDAB today.
Thank you, Janice, and my apologies. Please proceed.
Just a couple of outline housekeeping items, as that's what I've sort of outlined here for myself to talk about today. Stone Creek, of course, is a developer in the community, as is known, and just further up Silvertip Trail from this development. While in favor of commercial development, as noted in prior occasions, in respect of this development, insofar as the proposal under review, main concern has always been and continues to be compliance with the DC bylaw and the other planning instruments that apply, and not putting critical components of compliance out to another day to where we don't have the oversight that the compliance will be achieved. Stone Creek remains steadfast that they are looking for firm commitments to demonstrate and ensure compliance with planning instruments, and so we do not have to chase down things that are going on behind the scenes or engage in further appeals. Well, as noted, Mr. Hammersham has already introduced himself, and he has indicated that he is who he's representing. We also do want to make a note that the owner of the property is Canmore Hotel and Spa GP Ltd, which does have an association with the ownership of the Base Camp Resort group of companies. And so the only reason I mention that is throughout our presentation, we may sometimes refer to Base Camp, and that's basically referring to the applicant group, or we'll refer to the applicant. There will be 2 development permits that will be referred to at points in time during our presentation. I'll refer to the original development permit application, and that's the permit application PL 2023-0037. I'll refer to that development permit either as the 2023 permit or original development permit. I will try and differentiate between that and the permit that's before you today. Also, that permit relates to the SDAB decision, which is under appeal at the Court of Appeal, and that is an active process. The second development permit application that I'll refer to is the one before you today, and that is PL 2024-0362. I will generally refer to that as the current application or new DP, and if there's any confusion along the way, because there are a few items active, that I would ask that you interrupt me just for clarification if needed. Thank you so much. I would like to say that I'm new counsel on the file. While Stone Creek is a client of mine for some time, I did not do the prior appeal. So this whole appeal process and what occurred previously, the plans, all the discussions that have occurred, I'm not privy to any of that information. So I'm basically starting from scratch outside of knowing what, the development and the development appeal going forward. In a general sense, I do not have all that background information. So it's taken a bit to catch up because there's a lot of moving parts, but I just wanted to make note of that just so you don't think that, I'm on board for the whole process that's occurred over the past year. I haven't been. The scope of our presentation today, we made it known at least on December 17th, in our notice of appeal that we would be asking for an adjournment. And we did later indicate in our letter January 8th that we would be asking for that adjournment, plus consideration of a new panel for the parties that actually hear the merit hearing. and then that video attendance today was going to occur and might be our preference. Part of the basis for that request on January 8th was, at the time, we had agreed with opposing counsel that we would discuss preliminary matters today. And so we felt that video attendance might be appropriate. On Friday, we got the notice from opposing counsel that they were bringing up a new matter, which is trying to strike our appeal today, as far as I can tell from what we have so far. We have received no written materials to date about their application today to strike. To date, we have received some handouts today, but we have no written submissions. And outside of the handouts today, we have no information about their strike application today. Again, first notice of the strike application today was on Friday. And again, we had talked about with opposing counsel that we were going to focus on settlement discussions up until the end of last week. And we agreed that we would postpone efforts on written submissions for the full merit hearing to work on settlement. If settlement didn't occur on the 10th, which was Friday, that we would then put our efforts into preparing for the merit hearing. That is why today we have come prepared to discuss what we believe to be preliminary matters. That is the adjournment request, the composition of any panel for the actual merit hearing. We can present today on the issue of the strike application. However, we submit that we just got notice of that application and that was going to be before the board today. And we feel that it is inappropriate to go forward with a strike application when we have received no materials from the applicant in advance and we haven't had time to make written submissions. We can make some verbal submissions about some of the grounds of appeal we have going forward. But we, in looking at it in total on the drive here, I came to the conclusion, and we present this to the board, that we believe today's meeting should be solely for addressing how we get to the merit hearing and not attempting to cover a strike application. A strike application is basically an application to say that the other party has no merits to their appeal. Well, how can you determine if there's no merits to their appeal or no grounds available unless you get into a full merit hearing? So we say it's peremptory, it's preliminary, it wasn't known to us until Friday, and therefore we have had no time to prepare. So, let's see. Yeah, okay. And if the board, for some reason, is going to hear the strike or dismissal application today, because of the late notice and because we've received no materials to date, we would submit that, of course, it's not reasonable to go ahead to do what amounts to a merit hearing on short notice. But we can do verbal submissions, and we reserve the right, if we are going to go down that path, we reserve the right to provide written submissions, evidence, cases of our own to oppose that application. Just with respect to filing of the appeal to today's date, I just want to give a few facts because it gives you a bit of flavor for where we're at. We filed the appeal on December 17th. Our appeal was not due until December 26th. We decided to file it before the holiday break so that people knew that it was filed, and hence we're at this board within 30 days, which I believe would have been January 15th, and we're here on the 13th. Had we actually filed the appeal on the 21st date, which is common, you file it on the last day of the appeal period, the 30 days would be taking us into next week. So we probably wouldn't even be with you today. We might be with you next week. So we're already a week ahead, if you will, of schedule in terms of just because we filed our appeal a bit earlier. Excuse me. With respect to the facts, The actual CPC report, I'm not going to get into the merits of the hearing, but I will get into just a discussion about what's occurred to date. The summary of facts in the CPC report, which you will have before you, and that includes some of the facts within the SDAB report that is before you. Those are a limited set of facts in the sense that the CPC really only went through their amended conditions. So it's our view that that wasn't the fulsome review that needs to take place at this board, and that that because there is a pending Court of Appeal application, that does impact the situation. The CPC video with respect to the hearing that took place for the CPC decision that's under review today was a matter of 14 minutes long. And about 7 of those minutes were dealing with administrative matters. So really all the CPC meeting that you could tell online did was look at a couple conditions of approval and decide that they were going to proceed with those couple amended conditions of approval. And there was no further dialogue about any other matter. Now, a procedural question was asked of one of the panel members, and I think it's important, is that one of the panel members asked the chair, I believe, that, what of the Court of Appeal matter does it, impact anything that's going on with respect to the CPC review? And at least from what I could tell from record, and I think we should admit the CPC video into evidence in this SDAB hearing, is that the person who raised that item was told that it wasn't a relevant planning matter, and therefore there was no discussion about that. So there are items like that that need to be brought forward in terms of what is the intersection of the Court of Appeal process, where the prior SDAB original permit is under review and still under active review, and what is before you today. And we submit that that should all be part of the presentation under the merit hearing that would go ahead with at another date. One of the items that might arise and be raised by the appellants is, or applicants, I should say, sorry, is that base camp is well under construction, we're holding matters up, and we simply disagree. Base camp is well aware that whatever permits they have been issued to date, including building permits, are at their own risk, and proceeding with construction while there's still a Court of Appeal process can also be a risk. So we would suggest to this board that we are not looking to delay construction for an inordinate amount of time or an unreasonable amount of time. We're simply asking that the merit hearing, that today we discuss the adjournment and the panel, and that we figure out a format for the upcoming merit hearing, when submissions are due, what date that merit hearing can take place. And I had raised the fact about the panel composition, because if you're worried about what dates we can schedule this, and if you have to have a different panel, then that might impact what dates their folks are available in terms of membership. So, let's see. I should advise as well, there's a couple important things by way of dates that led us here, and again, I've expressed some of them already. January 2024, February of last year was that original development permit decision. And then we get into March where we appealed it. And then we get into an appeal hearing in April, and then finally in May. I can advise that the development permit plans up to that point in time are not the plans that we're looking at today. So the prior plans before the Subdivision Development Appeal Board hearing have been updated, and so we have not been privy to the content of the plans that are before you today. So if there's some thought that we had prior notice of the plans, have had time to review them, We haven't. There appears to be a set of plans from July, a further update in September, and then another further update in November. So we've got various plans before you, and if you look at the legend, you can tell that they've been updated in 2023. Typically, that was the first set, and then they've been since updated, but those updates have never been part of an SDAB hearing, and those updates are, in our opinion, significant. Yeah, and just in terms of the Court of Appeal process, that was filed in, let's see, June. And then, again, I refer to over the summer and into the fall, there were revised plans, again, never part of this process. And then into October, the Court of Appeal ruled that, Court of Appeal Justice Wakeling ruled that the 5 questions of law about the prior SDAB decision on that original development permit were going to go through to the panel of 3 justices. So in other words, the actual SDAB decision on the original permit is still the subject of further review by the Court of Appeal, and that is still ongoing. And the other important date is November 28th. That's when the decision was rendered by the CPC on this permit. Again, I want to emphasize, we had no knowledge that the application was going in or that it existed. We had no review of the plans since before the SDAB, the past SDAB hearing, so there's a lot of amendments. And so we don't have any background knowledge. I happen to be on the Town of Canmore website, and I looked at recent development permits and notices, and I happened to notice this particular site, a DP application had been made. So without that, we would have had no knowledge. There was no consultation with Stone Creek, and again, no knowledge of the new plans, revisions, etc. There may well be a lot of solutions in those plans to prior appeal issues, but I say that this should be an active appeal before the board and a merit hearing to go over those plans and be given the opportunity to comment to see if they still meet the directions of council or whether they do not. So that's a couple dates and a couple important details regarding the background to today's date. With respect to the preliminary matters, and I assume you just want me to cover the adjournment request first. Would that be fair to say, Mr. Chairman?
Yeah, if you could make the request on that, and then before we can proceed, we need to decide whether or not an adjournment's going to be taking place. So
Sure.
I would ask that request now, please.
Thank you, and I won't talk about then the panel composition. I assume you would like to hear from Mr. Hamersham before we get on to that second issue. Perfect. Just as a matter of course, adjournments, of course, are at your discretion, and we are aware of that. Some factors that come into play that the board will look at in considering such a request are, will the adjournment better ensure a fair and reasonable process? What is the prejudice to the parties of granting the adjournment? And the emphasis in the MGA is on not delaying development. In our appeal before you, and in our discussions with the applicant team, is that we had originally agreed on a 1-week adjournment, and we had indicated that we need slightly more, 2 to 3 weeks. So the adjournment was agreed to, and Mr. Hamersham can speak to that when he gets up here, but it was largely agreed to beforehand. It was just a matter of timing, and we indicated that we needed we need further consultant information in order to prepare our submission, so that is why we asked for 2 to 3 weeks. And 2 to 3 weeks in our letter, September 8th, would put us at a hearing date somewhere around January 29th, or a few days, or within the 1 to 2 weeks in that zone after that. And we put that in our letter. Again, we just requested a short adjournment of 2 or 3 weeks, which in our view is not unreasonable in the circumstance. As I noted before, we're a bit ahead of schedule because we filed our appeal early, so we're in fact a week ahead of schedule already. The other important item, item number 3, is that the SDAB report, we just received the SDAB report 2 business days ago on Wednesday. I know that's the appropriate timing and there's no criticism because we had to bridge the holiday break. So the report was received just 2 business days ago, and it's 248-page report. And we received the report after the deadline for written submissions. So the deadline for written submissions is at 9 a.m. last Wednesday, and we received the SDAB report at 4 p.m. approximately. Item number 4, I'm new counsel on board, so I don't have a background. Mr. Homersham's been involved in the file for some time, I understand, and that team has sort of stayed the same, if you will. Our team has changed up for Stone Creek. Item number 5, again, settlement discussions. We had agreed to postpone developing written submissions so that we could focus on trying to settle for the week before the hearing up till January 10th. So that is why you don't have fulsome written submissions before you. That was, again, anticipated in discussions with base camp team. I can advise that because I'm new on the file, I had reached out to some other parties to determine why we are where we are and what's happened to date, which I think is only prudent for either settlement discussions or moving forward with the appeal. And in those discussions, we had reached out to the town to see, you know, what's the background on this file and why are we sort of stuck a little bit. And item number 7, in terms of the request for the adjournment, is the SDAB package has several versions of revised plans. I can tell you it takes a very long time when you're not the applicant and intimate with the plans and have the plans available by way of AutoCAD, etc. It has taken some time to go through the plans. My first degree is in architecture, so I have the benefit of reading 3-dimensional plans, 2-dimensional plans, and envisioning spaces. So, but even for myself to go through the plans, it has taken a very long time to determine what exactly has changed, where, and what impact that has on directions of council, etc. So just to say that this appeal before you is just related to 2 amended conditions as occurred at the CPC hearing, took all of 7 minutes. We suggest that is just not the level of detailed review that's necessary. And item number 8, we suggest there's no significant prejudice to base camp as we are in the winter season. So a couple of weeks at this point in time is not a significant request in terms of postponing the hearing. We think it is actually better for everybody that we put our efforts into proper submissions, one time, particular dates, and then know ahead of time when the hearing date is. That to me makes eminent sense to proceed in that fashion rather than piecemeal and have some items occur today and maybe some items occur at another date. And finally, we are definitely within a reasonable time frame that would be considered at pace for an appeal of this type. Again, the MGA does like to have these hearings occur within 30 days. I can tell you from my experience, and I've been doing this for just about 22 years full-time in the municipal law area, almost no hearings of any significance occur within 30 days. There always is, almost always is some need to organize how the appeal is going to go forward, and we think that's prudent in the circumstance. With those dates in mind and a bit of background, those are our submissions on the request today, which we feel is reasonable, and we have provided dates that we are available in the near future. Thank you.
Thank you. Seeing as we have a request for adjournment before us, I think we need to right. Sorry, I was just going to ask a procedural question. On an adjournment, does the applicant, we can proceed with their rebuttal to that? Or before? Okay. Okay. Thank you. If the applicant would like to speak to the request on the adjournment, please.
And I have a procedural request or question because the issue of the composition of the panel and the apprehension of bias that's alleged by the appellant, in my view, the board has to make that determination prior to it considering the adjournment request. Because if you determine that there is an apprehension of bias and the panel hearing this appeal needs to be reconstituted, you have to adjourn to conduct that. So I'd ask the board to consider hearing the arguments from the appellant first before you hear my arguments with respect to bias and adjournment, so that you have both those arguments together and you can make the decision on whether or why you need to adjourn, if at all. If that makes sense to you, I'd ask the appellant to come back to the podium. Or I can proceed. Your call, of course.
I'd like to suggest to the board that we confer with legal counsel on where we are so far as on those two requests, and but I'll need a motion to do that, unless the board's prepared to proceed.
There you go. Thank you. Thank you, Mr. Chair. I'll make a motion that we go in camera to discuss the applicant's request.
All in favor to go in camera to confer with legal counsel? Okay. At this time, the SDAB will go in camera to confer with legal counsel.
There's no wrong.
Thank you, everyone. We'll call the meeting back to order, coming out of closed session. At this time, we'll allow the applicant to speak to the adjournment.
We good?
All good.
Okay. Mr. Chair, members of the panel, for at least my own edification, the decision that was made in camera, I intend to speak to the adjournment request, but I also intend to speak to the issue of bias. We haven't heard the appellant's arguments, at least not in full, why there is bias. She's quoted the test for apprehension of bias in her written submissions, but nothing more. If they're prepared to rest on that, I'm fine with that, but I'm asking the board if, with your permission, if the decision was, I can speak not only to the adjournment request, but to the issue of apprehension of bias.
Yeah, I believe we've heard the submissions on your request for the panel change, okay, all right, having my error. We'll hear on your submissions on the adjournment first, and then we'll proceed as a secondary item on the panel change.
Okay, so adjournment,
Then
submissions, and then
Correct.
the appellant will speak to bias, and I will speak to bias. Is that-
Correct.
Thank you.
That's two separate items.
Okay.
Go ahead.
If you could, during your presentation, address why you believe the board should hear today the application to strike.
Certainly. You want me that as part of this or at some point? Okay. Thank you. With respect to the adjournment request, I want to, I'll say correct, but give my view of the discussions between the appellant and applicant on possible settlement of this appeal. And in those without prejudice discussions, and they were without prejudice, which is how you typically have negotiations to settle a dispute, so that statements made or positions offered during those settlement discussions cannot be used against you in the formal process, and we are now in the formal process. So I disagree with the appellant's submissions that we had agreed to an adjournment date. We had discussed adjournment dates. We did not agree, and I'm happy to disclose within those without prejudice discussions that we were prepared to have this adjourned to the following week, so next week, but no further. That was never agreed to, but as I say, that was part of the settlement discussions on a without prejudice basis. So really, it should not be before this panel that we agreed. So we don't agree to an adjournment, and part of the reason why is that there is significant prejudice to the applicant because, of course, the development permit before you that is being appealed isn't issued until a decision is made by this board to approve it, if that's the case. So this development is being held up when it is difficult to get and schedule trades, and time, as you'll hear from my client, who would also like to speak to, and I think it's important that the panel hear this, who'd like to speak to the differences between the first development permit and the second development permit and the reasons for that second development permit, because they are almost entirely on-site amendments to deal with emergency access and rerouting a pathway through the property and resizing pools and whatnot, none of which were raised as issues on the initial appeal, nor are they raised on issues as issues in this appeal. The only issue that I can surmise that the appellants had that was with the first appeal that was addressed with this second DP is the removal of the pathway that with the first development permit application was shown contextually to run along Silvertip Trail and occupy a portion of one of the lanes. That was a significant concern for the appellant, but that is no longer part of this current DP. So we are opposing the adjournment request because we don't know and we can't glean, and it's not our role to have to glean from the notice of appeal what the appellant's grounds of appeals are. Now, those aren't getting into merit. We don't need a merit decision. The appellant has a right to appeal. It's an affected party, but it also has an obligation to make out what those grounds of appeal are. And so I would like to now, as part of my reasons for opposing an adjournment request, is to go through in detail the notice of appeal and argue, demonstrate to you why there's no appealable issues in that, and for that reason it should be struck. So just bear with me, I'm going to grab the notice of appeal, which is back here, so I can refer to that. So the first grounds of appeal, and I'll read it, labeled number 1 on the notice of appeal, says the development authority has no jurisdiction to grant an amendment of a development permit which is under appeal where Stone Creek was granted permission to appeal by Justice Wakeling of the Court of Appeal in September of 2024, and a final determination of that development permit has not been made by the panel of 3 justices at the Court of Appeal. That is an incorrect statement, panel, of settled law. An appeal of an SDAB decision does not act as a stay. The SDAB's decision to approve this current DP is not held in abeyance or stayed until an appeal by the Court of Appeal is ultimately determined. That, and I do reference the law on that. The Court of Appeal did opine on that, and it's also referenced in planning law and practice in Alberta, LOCS, which is kind of the seminal text for planning issues in our province. So I do have those. I don't know if you were given copies of those. I did give copies of those references to my friends. But the development authority is not prevented from issuing another DP with respect to similar development on the same lands. It's the Court of Appeal in a case called Macaulay. Sorry, I'm going to get that. Sorry, that comes up in the next point. This is what I'm referring to, I beg your pardon, is a reference to the rules of court, which says that an appeal does not act as a stay. An applicant or an appellant can apply for a stay of a decision until the Court of Appeal matter is heard. The appellants have not done that. So there's no implicit or inferred or otherwise explicit stay of a development permit application, notwithstanding that, or even if the DP is under appeal to the Court of Appeal. As my friend mentioned, our proceeding under the old DP, because the current DP that we're discussing today hasn't been issued, that is being done at our risk. If the Court of Appeal were to overturn that decision, then that risk for us would come to fruition. But we are not in any way legally bound to not proceed under that development permit now that it's been issued. So I'll go through, as I said, each of the numbered notices or grounds of appeal that are raised. But the overarching.
Mr. Chair, apologies for interrupting, but I'm wondering if the board shouldn't discuss whether they're prepared to actually hear the application to strike now, or whether that should be adjourned.
This goes, may I address that? That, as I said earlier, this goes to the issue of whether you should grant an adjournment. If there is no grounds of appeal laid out in the appellant's notice of appeal, you have nothing to adjourn. The application, the appeal should be struck. So it is our position that you do need to hear the arguments with respect to the summary dismissal or striking of this appeal for it not revealing any grounds of appeal, because that goes to the very issue of whether you should even consider an adjournment.
I understand your position, and I think the board does too, but I do think the board has to discuss whether it can even hear these arguments today.
So how do you wish to proceed then, Mr. Chair?
If you have any other comments regarding the, or rebuttal on the adjournment request, we'll certainly hear that, and then we'll.
Okay,
decide
well,
on the adjournment.
if I'm not going to be allowed, and I do object to that, I think it's not the correct ruling. But if I'm not going to be allowed to make the case that there are no grounds of appeal listed in their notice of appeal, I will make the case generally to say we oppose an adjournment request. An adjournment request is not required because you would be adjourning a matter that should be struck in the first instance. I'd be happy to go through those specific detailed grounds, but I'm getting cut off from what I understand.
Thank you.
So I will address the arguments of bias after the appellant does then. Thank you.
Thank you. Before we proceed, any questions from the board on the applicant, for the applicant? Okay, thank you. If you would like to proceed on your issue of the panel.
Good morning again, it's Bonnie Anderson for the record. With respect to the second preliminary matter before you today, which is the panel composition, it is contained within our January 8th letter, the test, and I'll restate it here. And this is, to me, out of an abundance of caution. And if I've missed anything, my co-counsel, Ms. Stokes, may get up to speak. But so long as the matter of the STAB decision on the original development permit is still within the Court of Appeal process, and if the three justices of the Court of Appeal do hear argument on the matter of the questions of law we've raised, then the result coming out of the Court of Appeal could be, because they can't decide the matter in finality other than deciding the questions of law don't go through, they then provide direction so that the original development permit, the STAB decision, comes back to this STAB to address whatever Court of Appeal issues they have determined. So in other words, the Court of Appeal process is separate, but it could end up back before an STAB panel should we be successful in arguing any or all of the 5 questions. So that would mean that it would come back to this STAB, and that would mean that decision, as long as that development permit, which is the basis for the construction that they've undertaken, so long as that's coming back to the STAB, we have concerns that this panel and that panel in that prior development permit, which is the basis for their construction at this particular point in time, not be the same members. And we believe that in cases of reasonable apprehension of bias, that in this case, caution should be exercised such that should the two processes go full circle, we don't have the same panel addressing the same items multiple times, because we can assume that they will feel that they have to do what they did before. So we think that this appeal process would be better served by a new panel. Unlike, and the test I will review, but unlike what Mr. Homersham has suggested so far, we do not have a problem with the panel hearing, the current panel, hearing the adjournment request, hearing the request for a new panel for the merit hearing, and setting dates, because we believe much of that, if not all of that, is procedural in nature, administrative in nature. It is not getting to the heart of the merit hearing. So unlike Mr. Homersham, we do believe this panel can address the adjournment request and the panel request that we've put forward. My apologies, and I'm gonna just, oops, just 2 seconds here. Is the test, which we've stated in our letter, which is at page 43, I believe, of the board report. You don't have to go there. But again, we would request that a new panel be convened for matters addressing the merits of this appeal. And the reason for that, again, as we've mentioned, is that by way of background, we're still in the Court of Appeal process for the original development permit. This permit that we're looking at right now is looking to amend conditions of that permit that's in that process, looking to just amend conditions, and then looking to cancel that development permit, import some of the conditions into this development permit. So to me, it is our submission that the two should be separated apart, and we should be careful with the panel in case that Court of Appeal process results at the questions coming back to the SDAB with directions to make a decision on that original development permit. So we suggest that applying the well-stated test for purposes of determining the question as to whether there's a reasonable apprehension of bias, it's our submission that, and again, this is in our letter, a reasonable person having knowledge of the facts and having thought through the matter would conclude that an apprehension of bias could arise in the current appeal if panel members involved in that prior SDAB decision that is in the Court of Appeal process were asked to now amend and review conditions that are part of this appeal process. So that is basically our submission. Do you have any questions or?
Any questions from the board regarding that presentation? No, thank you.
Thank you. Those
Well,
are our submissions.
We'll hear from the applicant on the issue of the panel at this time.
Thank you, Mr. Chair, members of the panel. The issue of bias raised by the appellant asking for a new panel to be formed that doesn't include members that were part of the previous panel that ruled on the, I'll call it the prior DP. The appellant, if it's going to raise that argument, should actually reference case law. Now, the case law on this is the one I mentioned earlier. It's from the Alberta Court of Appeal, and it's called Macaulay in the City of Edmonton. And there is a copy of that, and I've highlighted the section on bias, which you should have or will have, and my friends have it. The statement from the Court of Appeal, and it's also summarized in Locke's, and I've highlighted that page from Locke's. The test is that bias is not made out simply because a panel member has sat in judgment on a similar appeal. That is the summary of the test. Now, I want to read more specifically from Macaulay because it does go into the reasons why apprehension of bias isn't made out simply because a panel has heard a similar development permit. And so I'm reading from Macaulay from the section that is Section B, entitled Bias. And I'll start from the second paragraph here. It says, no significant evidence other than his previous decision was presented to support this ground of appeal, meaning bias. That is important because this type of attitude bias has different rules than other types, such as pecuniary interest or family or marital connection to a party. Opinions do not amount to operative bias, real or apparent, unless they are so firmly held that the usual course of argument cannot overcome them. In particular, a member of a tribunal is not disqualified from sitting merely because he or she has previously heard and decided similar cases. Now it goes on to examine the reasons for that with the tribunal in terms of their expertise and their accumulation of that expertise by hearing a lot of applications, and also that there's a limited number of expert panelists, so unless there is another type of bias, or it can be proven that there is an actual bias, an attitude bias, actual rather than just an apprehension of bias, an alleged bias, that those panelists should not be disqualified from hearing a similar appeal. We have a similar appeal, of course, before us now. So there is, in our respectful submission, there is no apprehension of bias that this panel needs to worry about. There are 3 members, I believe, on this panel that sat on the previous appeal, and you are deemed, unless it is proven otherwise, it can't just be alleged unless it's proven otherwise, that you have such a predisposition that cannot be overcome through the course of arguments before you. And I don't believe that to be the case. So I would ask that this panel remain for the course of this appeal. Now, my client, Mr. Fisecki, would like to also make a few submissions, if he could, on this issue and other issues. Thank you.
Sorry, before we proceed, any questions from that? No, thanks.
Good morning. For the record, my name is Biral Fisecki. I represent Base Camp Resorts. I'm going to take 2 seconds just to set up. We had some technical challenges at the front end. Now, I will be cautious to only speak to the matter of an adjournment for the benefit of the board. Once I figure out how to turn on my colleague's computer. There we go.
Sorry, I can't. Do you have a? You're saying you haven't been given a copy of these materials?
We've been given cases, et cetera, from Mr. Hamersham from this morning, which we will speak to because I didn't address one item. But we have no copy of the materials that were presented by Mr. Fisecki, and we are wondering if the materials are going to stick to the sole question of adjournment or go through the whole reason why this application is before the board. So that's my only caution.
I'm quite confident they'll stick to adjournment matters, but again, I'm happy to be reined in because it does kind of, a lot of this intertwines with one another because it is important to emphasize, I think, that both groups, and I do want to go over the history a little bit on timing, but both groups, in the spirit of coming to an agreement, have been working very hard throughout the summer. I'm talking lots of hours, both legal and planning being involved. So I do think I can contain it to the adjournment, and I'll try my best to.
Okay. No, if, I do ask that we stick to the issue of the adjournment.
Absolutely.
Thank you.
So we received our first DP, as mentioned, by CPC on February 21st of 2024. The approval was upheld by SDAB in May of 24. Now, we know that Stone Creek had continued to go through an appeal process with the Court of Appeals, and we know that this is going to be heard. What's really critical about this slide here is the fact that Stone Creek, they do consider our spa, they're noted on record, that they consider this to be a welcomed addition to the area. They further went on to say that they do support the development. And where this is all really relevant for the point of an adjournment is timing is critical for us. That's why throughout the summer, we were willing to do, well, anything. Mr. Turcotte really identified, especially back in May, he said, I have one major issue. And that one issue is that the town has contextually put a lane closure on your site plan that will convert to a pathway. He said, get that off your plans, and I don't have any issues. That was May. We got it off the plans. Like the town they've stepped up. Your town administration has been phenomenal through this entire process. They provided written documentation to previous council and this council that the identification of a pathway will come off the plan. And not only will it come off the plan, the town has no planning budget allocated for the next 2 years for a pathway. They have no plans for a pathway. There is a global transportation strategy, but they didn't go into details about, or they emphasized that there's nothing on the books today, which really did satisfy Mr. Turcotte's key reason. That then spilled over into the notion of screening, to which we said, no problem, we'll talk to the town. The town again stepped up, allowing us to plant trees in a town right-of-way that would create the appropriate screening. Now I have other things which I'm not going to go into, which identify all the things we've done for the Stone Creek folks. And that's, if we go to a hearing, I'm hoping today, if we don't adjourn, you'll actually hear what all those things are. But I think my key message here and my plea to all of you, as council suggested, oh, it's no big deal, it's wintertime. It is absolutely a big deal because the ripple-on effect is we're trying to get a spa open for October. We can't do this if we don't start framing this month. Like, it's plain and simple. And it's not as easy as once a framing crew is gone, they go to another site, and these framing crews are highly technical. They're not single-family home framers that you can just pick up somewhere. You're booking these framers so they can get to your site, and if they go somewhere else, you're month to 2 month delay. We can't risk that. So it is financially a massive impact to us. And I just want to emphasize here that, you know, both councils did a great job on the legalese. I'm not a lawyer. I get scared listening to both councils. And I've been in the business for far too many years, I'd like to admit. I want to suggest to this panel today, I do think you have the right to not adjourn and you have a right to rule today. The bad news, and please don't take offense to this outcome will end up in the Court of Appeals. That's clear now, because if you continue and vote in our favor, we know that's going to be appealed. If you adjourn and the next panel votes in our favor, it will be appealed. If the next panel does not approve the amendments, well, then we're back to the original DP, which is already being appealed. We're going there no matter what. So my plea is let that happen. It can happen on a parallel course. You guys can approve or uphold our DP today. We can get our building permits. We know that, as they've said twice now, they have no objection to the spa itself. Mr. Turcotte has gone on record multiple times saying that. They have no, I can show you the changes if we proceed. They're so minor within the site, and they all relate to requests, or most relate to the requests of Stone Creek. It is so benign. everything is external to our site, and everything needs to be dealt with through the Court of Appeals. So my plea is don't adjourn. And I'll show slides later if we get there.
Any questions from the board? Submissions? Thanks. Thank you.
Thank you.
Just quick procedurally, we've heard on the issue of adjournment and on the panel, we had a third one of the motion is strike. Are we wanting to? Okay. Yeah, go ahead.
Good morning. For the record, Samantha Stokes. I had one point in response to Mr. Homersham's reliance on the Macaulay case. In that case, Mr. Homersham relies on it for the idea that there's not a reasonable apprehension of bias if you've addressed similar appeals. And Mr. Homersham didn't read into the record paragraph 2, and I think the first two sentences are particularly salient to this point. And so it says, with respect to bias, the first ground of appeal proposed is freestanding. The chair of the 5-person panel of the board hearing the matter had previously decided a similar appeal or appeals on another lot or lots. The issue with respect to potential bias of this panel is that you've already decided in respect of this lot, this development, which is before the Court of Appeal, including conditions which were amended by this by CPC that are specifically before the Court of Appeal. So while the Macaulay decision does address reasonable apprehension of bias, the factual scenario to what is before you is distinguishable, and so therefore we still maintain, even in light of the Macaulay decision, that there is a concern, and we want to ensure that everybody's decision is independent from each other's. Thank you.
Thank you. Any questions? Anything to, with you?
Do I get an opportunity to respond?
Absolutely. The applicant will respond.
Thank you, Mr. Chair, members of the panel. The Macaulay decision is right on point. I didn't deliberately skip the paragraph that my friend read from in part, but I do highlight it in the copy of the decision I give to you. And it does refer to a panelist who had given a written decision on a prior similar appeal. That is the basis for the argument before the Court of Appeal, was whether that disqualifies a panelist, a tribunal member, someone with expertise, from sitting again on a similar appeal. So it is, in my view, not distinguishable, as my colleague argued.
Thank you. Anything from the panel so far? Shall we have the third issue of striking the application? Are we prepared to proceed with that, or should we deliberate on the two issues before us?
I'm prepared to make a motion to go into closed session to seek legal counsel and deliberate on the first two matters.
Okay, thank you. All in favor on going into closed session? Moved. SDAB will proceed to a closed session at this time. I'm sure we can help you.
They saw them just all leave without me.
Thank you, everyone. We'll come back to order. After consultation with our legal counsel, the SDAB has decided to grant the adjournment and to deny the request to reconstitute the panel. Reasons for the decision will be will be provided in writing as legislated, as per process. And we will reconvene within 30 days in coordination with the clerk for the next hearing. Did I get that all correct? Okay. The SDAB stands adjourned at this time. Concluded.
Do we need a motion?
Sorry, before we adjourn, so we don't have a date yet then for
Within 30 days of today. So the clerk will work with both sides to nail that down.
We'll have to make sure this is a date that works for everybody involved.
Okay. Motion to adjourn? We stand adjourned. Thank you.